morning, Judge Kolakowski. As a mediator, I'm a non-attorney mediator, and there's a bit of a controversy around non-attorney mediators, especially in the legal field. I feel like there's a lot of pushback by attorneys who feel like I'm subpar to another mediator who has a legal background or who is specialized. So I'd love to know your take on attorney mediators versus non-attorney mediators, if you have an opinion.
Okay, let me tell you a little about my experience with mediation, which is that I went through the 40-hour mediator training twice. The first time I did it was not as an attorney. It was actually in a church, and because we were trying to develop people who be community mediators, and all the people who were there, none of them were. I think I was the only attorney that went through that training, and there was a time where where there were people. There was I don't know whether this is still as prevalent, but the desire to try to get people to do mediation for even outside the normal legal profession, like just roommate issues and things like that, and neighbor issues, and other things where you had just people who were having conflicts with people. And then when I was an administrative law judge at the California Public Utilities Commission, I was trained as I went through the mediator training again, and I was one of our ALJs who were trained mediators and were available for settlements. Now, one thing that most people don't know is that not all administrative law judges at the Public Utilities Commission are attorneys. There are non-attorney ALJs there who are, for example, accounting professionals or administrative professionals who are subject matter experts who can help handle the really complex issues that arise sometimes in utility regulatory proceedings. And so there are far fewer of them now. There's been this real push against having non-attorney ALJs there, I think because they want to improve their professional standing or something amongst their peers. But I've worked alongside, and one of my best friends is an administrative law judge who's not an attorney. And so I point this out because I don't have the same necessary, and also I don't have one of the things that I discovered when I was an administrative law judge was if I did something and it was reported in the newspaper, the headline would say, "Judge does this." Okay. If I called myself judge, the Superior Court judges would all say that I was, lying and being unethical. And so that administrative law judges aren't judges. And there's some truth to that, but they're subordinate judicial officers, in my opinion, or they're related. I mean, they're still bound by certain ethical rules and things like that. And the reason I point this out is that I think that there's far too much. First of all, I think there's far too much of a kind of almost elite snobbery that comes with things. It's one of the things that I've also found that there are people who don't view me as an elected judge as being as good as the ones who were appointed because I didn't have to go through the vetting process that they did. I went through a different vetting process, with 1.5 million people and 750,000 registered voters. But they went through a vetting process with a bunch of lawyers and interviews. And so I think that both are reasonable paths. I personally think that the skills that you bring to being a mediator are not necessarily related to those of being an attorney. They can be related, but there are different skill sets, and I personally don't have a problem. Now, I will also tell you that one of the things, especially when it comes to ADR, that's not mediation, but when it comes to things more like arbitration and stuff, truthfully, for many judges, their retirement path includes going to work for a company where they would provide alternative dispute resolution services professionally. And so we kind of have I think that some of us may have a vested interest in trying to, kind of narrow the competition. This is, by the way, for those of you who don't know, the reason that you will always see when you start seeing lots of judges who haven't seen before showing up at like social events, when they're becoming retired, it's because they're now looking for clients, because they're now doing ADR, and that's a necessary part of their business development. As a judge, let's be clear, I don't have to do anything for work to come to me. The work comes to me whether I want it or not. Same thing, by the way, if you were a DA or a public defender. There's certain professions where you don't have to hunt for work. The work will hunt for you. But I point that out because I suspect that there may be a little bit of a bias there. Now, I will say that there are times when having an understanding of what are the reasonably possible outcomes of a situation might help you in getting to a settlement. But I do not see why that would require that you be an attorney. Yes, subject matter expertise. So if you're trying to settle, for example, if I'm trying to settle an unlawful detainer case, which I have to do from time to time, like next week, that relies more upon me knowing what kind of things happen in an unlawful detainer case than the fact that I have done, asbestos trial litigation does not give me any real insight into what's going to happen in an unlawful detainer jury trial. It doesn't. I mean, I get some general things, like I know kind of the way, trials work, but in general, if I were trying to choose between an attorney who had no experience and a non-attorney who had been dealing with that particular type of thing for 10 or 15 years, I mean, hands down to me, I'm going to go with the non-attorney. But that's me. And I'm not saying that other people would necessarily agree with that. And I'm terrified that, this is going to come back to haunt me when, 10 years from now, I'm looking for a job, part-time doing ADR services, and somebody says, but you said, but of course, judicial experience is the most important of all. But
we can edit that out anyway, so it's all good.
But no, I'm saying, but of course we know that. But what actually matters is settlement experience, and what matters is ADR experience. The things that make that. And there are different ways, different approaches to settlement. One of the reasons I say I love ADR, I ran saying I loved ADR. ADR is very important. One of the reasons that ADR is important is because you have options that you can put things on the table you cannot as a judge in a legal proceeding. There are things that you can, because often the issues that are involved in a dispute are not just contained within the four corners of a complaint, but there's especially if there's an ongoing relationship between people, there are all sorts of things, and there are remedies that are not available. I mean, as a judge, what can we do? We can do some type of injunctive release sometimes, and we can give money. That's about what we do. We can order something within very, very narrowly defined limits based upon a statute, and we can, assign money. And that's not always the best solution to people's problems. And I'll give you an example of a settlement situation that was really just totally unlike anything else. I mean, this was a situation where it was a tort case, pro per. A woman's son had died, had been shot accidentally in Oakland as he was coming home from playing at his friend's house. And this woman sued the friend's mother, saying that if she had called and told her that she was sending the kid home, she would have come and picked her up, and it wouldn't have been on the street, and he would have died. He wouldn't have died. Now, obviously, this is not, this is not a case that should go to trial. But, and I knew that this would be appropriate. I sent the case to Judge Harbin Forte, who is a wonderful, wonderful person at doing settlement stuff. And she's also a wonderful woman who understands people's grief. And so what she did was she had them talk, and at the end of it, they were hugging. Also, I think that part of Brenda's secrets was she had cookies, but I'm not quite sure. But, the thing was, she had them talk through about it. She had them talk through their pain, and it really wasn't about. She wanted a remedy that was not available, which was bring her son back, and you could litigate that, and it would have probably been thrown out, and everybody would have been so unhappy. But having to sit down and actually have some sort of mediation in that case led to a healing. And that's what I meant earlier about the fact that sometimes these things aren't just about legal stuff. And so, but that's the sort of thing that one can do in ADR. That I, as a judge, who was the judge in the case, could never have dealt with. And we would have had a motion for summary judgment, and we granted, and both sides would have walked away having with hard feelings and a broken friendship. And instead, what happened was we had two women who were both grieving over loss because this was a friend of the family, and you don't want that. And so that to me is a perfect example of a time when somebody used the legal mechanism for things that aren't solvable by law, but are perfectly solvable, can be dealt with if you deal with the interpersonal relationships that you deal with in ADR. Yeah. No, that's great.
Yeah, I'll get in touch with you. I'd love to have you come and chat with the ADR section. The only issue is that we'll have to figure out if it works for you or not, because we usually meet at noon on Wednesdays. I don't know if you can come during your lunch hour.
Sometimes, yeah. The thing is, I have a lot of committees that meet. I'm on all these committees, and they love to have noon meetings.